Stunt driving in Ontario, how courts differ and why it matters if you've been charged with stunt driving in Ontario. You might be surprised to learn that where you were caught could significantly impact your case's outcome. I'm going to walk you through the key differences between Ontario courts when it comes to stunt driving cases and explain why this matters for your legal strategy. I'm Jonathan Cohen. I'm a partner at Next Law, Ontario's dedicated stunt driving law firm. Let's break down this complex topic into three main areas. One, the diverse landscape of Ontario courts. Two, how prosecutors approach stunt driving cases. And three, factors influencing court decisions. First, let's talk about the diverse landscape of Ontario's courts. Did you know there are over 70 courts across the province? Each one of them has its own prosecutor, justices of the peace, and local practices. This means that the approach to stunt driving cases can vary widely depending on where your offense occurred. In Toronto, for example, courts see a high volume of stunt driving cases. This often results in a more standardized approach, but don't be fooled, outcomes are far from predictable. Toronto prosecutors are often well-versed in complex defenses and have many specific guidelines for these cases. Contrast this with Brampton courts, which serve a rapidly growing population and often face case backlogs. This can sometimes work in a defendant's favor, as prosecutors may be more willing to negotiate to clear cases quickly. Now, let's move on to how prosecutors approach stunt driving cases. Prosecutors have considerable discretion in handling these cases, especially when they believe there's clear evidence supporting the charge, for example, an accurate radar reading. They can recommend penalties anywhere within a broad range. That's why there's a range of $2,000 to $10,000 in fines, or license suspension from 1 to 3 years, potential jail time up to 6 months. The prosecutor's recommendation can significantly impact your case's outcome, making their approach a crucial factor to consider. Finally, let's discuss the factors influencing court decisions. These can include local concerns about street racing or dangerous driving, court resources and caseloads, individual judicial discretion, community impact of stunt driving. Now, given these variations, it's crucial to develop a legal strategy tailored to the specific court handling your case. At Next Law, we consider factors like court history, prosecutor tendencies, local issues, evidence strength, and your personal background when crafting a defense. So what does this all mean if you're facing a stunt driving charge in Ontario? It means that your case is far from a one-size-fits-all. The court handling your case, the assigned prosecutor, and local factors can all significantly impact the outcome. And this variability makes seeking experienced legal counsel who understands these nuances absolutely critical. While friends or family might share their experience with stunt driving charges, their outcomes are not predictive of yours. Remember, the penalties for stunt driving can be severe, and the variables are many. If you're facing a stunt driving charge, consider the complexity of your situation and seek experienced legal counsel to navigate this complex landscape. If you found this video helpful, please give us a thumbs up. Subscribe to our channel for more insights on stunt driving laws in Ontario. If you have any questions, for example, about how different courts might handle your stunt driving case, drop them in the comments below, contact us directly, and we'll do our best to provide some general guidance. Thanks for watching, and remember, when it comes to stunt driving charges in Ontario, where you were caught could be just as important as what you did.